very much, Professor Bashev. Dear colleagues, dear judges and colleagues of the panel, I'm here to go further with the Supreme Court of Russia. Well, I would like to say something about the theoretical tools and the practical tools we are as judges using to deal with some of these complex problems. The first one is the place of the principle of justice in the legal system. As the professor wrote, can fairness be a criterion for the correct interpretation of legal provisions? Well, we had 10 years ago a decision in our court. It was a very hard decision in the field of crimes against humanity, where we deal with the problem of a law against the Constitution. Can be a law be unlawful? It was about the law which declare some amnesty laws, declare prescription about the prosecution of crimes against humanity. And after a hard discussion, quoting philosophers like Radbruch, working roles, as you talk about here, we decided with a law, a strong moral and philosophical considerations, that these laws were null and unconstitutional. It established a principle in all the system, and in private law, this principle was very important in the new civil and commercial code, because we established the interpretation based on different sources of law and the protection of the weaker party. The second issue is about positivist normativism that the professor posed under the panel. A whole generation of jurists has been educated during an age of order, founded on a single formal conception of law, deduction as a basis for reasoning, remission to norms of founding recognition, and the principle of hierarchy, temporality, and specialty. Thus, the law in this system have a logical coherence made up the parliament of the Congress, and this is the work of the legislator, and the dogmatic, the judicial decision only reproduces this mode of reasoning. Nowadays, a whole generation of jurists is living in an era of disorder, in which there has been a phenomenon of materialization of law. The system is increasingly open and permeable to the incorporation of criteria that come from other areas, such morality, sociology, economics, technology, which are introduced through principles, values, indeterminate concepts. We can identify the following as causes of this phenomenon. First, weakening the rigid boundaries between the interdependent spheres of the public and the private law, passing to a system of communicable spheres. The second is the plurality of sources, both in public and private law. The third is that the coherence now is a posteriori, that a wide field is open for the interpreter, who must reconstruct the law on the case, through a process of selection of law, customs, ordinances, constitutional norms, principles, values. In private law, the code, our civil and commercial code, is within a system that integrates all the sources of law. We call it dialogue between sources of law. It's a systemic interpretation or a holistic, as our philosopher said. The Article 1 and the Article 2 refers of the Civil and Commercial Code that we have different sources of application of law. The Constitution, the international agreements, the customary, the law, different sources. This is very important because in a case the judge have to put in balance different sources of law, a dialogue. Not only the statutory language is very important in order to look for fairness, because nowadays in every system we have constitutional or international agreements that provide us values, and the judge must be neutrality of judges must be in relation with the interest of the party, but not in relation of values. It's very important if you have a position about the protection of the weaker party of the environment. The third question is the significance of commonly shared understanding of fairness. Our code establishes a relationship between individual rights and common shared values. For example, the Article 14 establishes that the law does not protect the abusive exercise of individual rights when it may result in damage to the environment or collective and diffuse rights in general. Also, the freedom of contract is limited with shared values and a lot of provision. We establish also the protection of the weaker party. We recognize that there are people that are outside the system, so we recognize the right of access, not only in access to justice in the sense of procedural justice, but also the access to housing, access to drinking water, access to the market. We have a lot of decision about this with new subjects. For example, the unemployed, the poor to litigate, the new generation on environmental cases. And when we talk about the weaker party, we are talking about in dubio pro, in Roman law, pro debitors, but nowadays we are in dubio pro laborers, in dubio pro natura on environmental cases. We have a decision of the Brazilian court, Supreme Court, that talk about in dubio pro natura because nature is a weaker party nowadays. We established that these kind of issues are very important. Just to wrap up the idea, we also increase the protection of the weaker party in our civil and commercial code, using a part of the code to regulate consumer contracts to protect specifically the consumer in the center of the system of civil law, and also a lot of provision about digital protection, because we have in front not only of differences between economic position, but also on the field of access to information. This is why it's so important, the cognitive vulnerability in the field of electronic or digital contracts. Well, this is our idea. We need to deal with fairness, but we need to understand that nowadays we have a long field to develop this idea, and the reality is that we have a lot of sources to put into account, taking into account also our values or the values of the system that we all have. Thank you very much.
Mr. Chairman, thank you very much.